What's up, y'all? Happy Monday. Excited to be here. We've got jury instructions this morning on the Jennifer Crumbly case. I've been saying it. I've been saying it since before the trial started. It seems like it's picking up steam. People are starting to understand just how big of a deal this case is moving forward in this country for parents. So this morning, I'm going to throw it up here and see what we can do here. Move this overlay here, which is a pretty sweet one. I wish I could make my picture a little bigger. So typically what happens with jury instructions is the judge will call the jury in, and jury instructions are always, they have what's called a jury instruction conference, typically during the trial. At some point as it gets closer to coming to an end, the judge will have the attorneys submit their proposed jury instructions. Both sides do it, and then they'll bicker about words, because words are everything. And you know, people are bored by the jury instructions when they're watching trials. And you know, whenever I'm in chat, if I'm on Jay's channel or wherever I'm at, I'm always trying to explain to people jury instructions are probably behind the jury the second most important thing about the trial, because it's the ground rules by which the jury has to abide by when they're back there in deliberation. So, and in the law, every word matters. Like, there is no word that does not matter in a jury instruction. So, and I've found during the course of my career that, you know, jurors really treat jury instructions as the Bible back there when they're going through. You know, if they have questions about the instructions, or if the instructions are not clear, you know, because the concept of reasonable doubt, there is no set in stone definition for that. You know, you could talk to 100 different lawyers and they'll all give you a somewhat varying definition of what beyond a reasonable doubt is in terms of standards. You know, and that's always challenging for jurors to try to figure out what exactly that means. And you know, it's an interesting psychological question in terms of what that means to different people. But you know, I'm curious. I'm going to do a poll pretty quickly, and the plan for the day will be do jury instructions. I'm not going to sit there through the verdict watch because I got to do an interview at 10, but these will be over before that. But I'll be on verdict watch, and if we get a verdict today, I anticipate this thing's going to be pretty heated back there. It would be amazing to be able to be a fly on the wall back there in the deliberation room while they're going at it. Because if you follow my Twitter, which is defense_diaries, and if you don't, you should. It's a pretty good active account. Give a lot of analysis. And, you know, I was posing a couple questions over the weekend regarding this case, and there was a ponderable that a subscriber had sent to me, which I thought was interesting, where you're subbing out a handgun and putting a vehicle in there, as opposed to shooting taking place that Ethan had taken a car that he was gifted or that they bought in order for him to use, you know, a few days before it. And instead of shooting, he plowed through a crowd of kids. Are the Crumblies being charged for that? I mean, theoretically, it's the same exact scenario, different mode of, you know, committing the crime in terms of it being a gun or a vehicle. You know, people were kind of getting stuck. Oh, well, you know, you have to take driver's ed. You know, he's like, let's just assume for arguendo's sake that he was of the age that he could drive and that he could have the car. You know, and you just sub those two things out. It's an interesting question when you really think about it. It's not such a clear-cut answer. A lot of people are like, well, guns only have one purpose, and that's to kill, and cars have, you know, a much different purpose, and that's to, provide transportation for us to be able to get back and forth to places. Very true. However, it's obvious that vehicles are absolutely in the wrong hands a deadly weapon. So I wasn't as convinced with that. There's poor Shannon. Poor Shannon reading all the press clippings. All right, Crumbly's coming in, and let's see. So after Crumbly comes in, they'll sit her down. Probably be some minor conversation with the judge. I mean, the judge wants to get these folks deliberating, and that's why they're starting bright and early today. Get them back in that room, and I'm curious as to what you guys think. I hope that there's some serious deliberation. Um, I always, especially in a case like this, where I've said it since the beginning of this thing. This isn't just a case. This is a case that's going to have a massive impact on our country in terms of how parents are treated in the criminal justice system with respect to their children's actions moving forward. You know, and it's that way. Either way the verdict goes. Michigan. This is really the first case where they've taken a shot at trying to hold parents responsible for one of these shootings, and depending on how it goes, it's either going to embolden other prosecutors across the country to move forward with the same types of charges, or it could have a chilling effect if, in fact, they come back with the not guilty. My gut on this, I cannot see a world in which all 12 jurors come back with a not guilty. I strongly feel this is going to be a hung jury. I think that the jury is going to be back there. I think that you're going to have it's going to basically be like any typical argument that you'd see online and social media, because ultimately it's going to, the concept of guns and gun control and gun reform is going to be brought up back there. It's going to be part of the conversation. And if there's a division in there, like there is out in the world, that's what it's going to be about in there. I mean, for me, it's a tough case, but the bottom line for me is that everything that preceded that day was significant, to be sure. But if I were sitting on the jury and the math test / writing / drawing did not exist, there's no chance. There's no chance I would convict her. The entire thing for me personally hinged on the fact that they were there that morning, that the original copy, because it somehow, apparently Ethan got his hands back on that test and altered it, scribbled some things out, added a couple things. I don't know at what point a teacher saw fit to give him that paper back for him to be able to do that. But Jennifer Crumbly was emailed the original copy, the one that we've seen many times. And that thing alone for me is, because I just don't care what anybody in the school would have been saying to her. If that's your child, if that's my child, I don't care if my husband has to work at DoorDash. I don't care if I need to go back at work. Nothing trumps my children. Nothing should trump Jennifer Crumbly's children, James Crumbly's children or child. And, they left him there. I mean, but for that happening, but for that very thing. And yes, like the school, culpable for sure. I don't know, and I should have dug in over the weekend, but I didn't, on exactly how they allowed for this to happen in terms of the school not automatically saying he's got to go. I don't know if they had to suspend him for the day. Whatever the case may be, he should have been out of that court or out of that school. All right, let's see what's going on. Excuse me. We've got our first meeting at the bench. Just so you guys know, I always, anytime they would do those at trial, I always wanted them to play that white noise because, like, it depends on the courtroom. Well, they turn the sound off, Nursey, because they're doing they're up at the bench. You guys could hear it prior to. There's no sound right now. They've turned the sound off because they're up at the bench. You guys could hear the sound prior to, right? She doesn't have a mic. There is no sound boosting the judge. They, for some reason, they don't have a mic up there with her, which is bizarre. So when they're done up at the bench, they'll put the sound back on. It's not us. Couldn't hear before the bench. Janet, it's not my sound. I don't know. Jay did say something about a sound booster. I don't have one. I'm pretty sure I have it cranked up as loud as it'll go without a sound booster. Yeah, and this will be brutal then because the judge is the one reading the jury instruction. So, let me see. I am, Todd. Been fighting this cold for like 3 weeks, man. It's brutal. Do I sound a little froggy? A little froggier than usual? Yeah. Oh, it shows you how much I love you guys because I should not be talking today. I should be resting my throat, my voice. Geez, thanks, Jedi. Yeah, I don't feel great. I don't feel great. Oh, thanks, Truth and Transparency. I don't think so. They're still on the sidebar. Like I'm streaming it through Law and Crime. There's no sound coming out right now. Oh, I paused it. Oh shit. Oops. Thank you. All right, game on. Whoa. Whoa. Jen. Wow. Thank you so much. That was incredibly generous. Thank you. Thank you. Yeah, I don't hate her either. I really don't.
I'm going to read you some jury instructions. You're going to hear these in the jury. So I'm going to pick back alternates. I know that you've all been in two different jury rooms, so when you're brought together, it's survival and the teams are merged. The tribes are merged, right? So I know you've been in two different jury rooms, but we'll be putting keeping the 5 alternates still sequestered in Judge Anderson's jury room, and the 12 will be in my jury room. That's why I asked you to bring personal belongings to the game. Members of the jury, evidence and arguments in this case are finished, and I'll now the structure of the law. That is, I'll explain the law that applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you in the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I said. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of crime beyond a reasonable doubt. The defendant is not required to prove her innocence or doing anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a mere honest doubt, going out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case,
using the word reasonable in the definition is not helpful.
Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted as evidence, and anything else employed to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say and they're supported by the evidence, or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses.
Thanks, Joe. Love you, buddy.
My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, we excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything the witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender or gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony to accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that is true and ignore the rest. James Robert Crumbly and Jennifer Lynn Crumbly are both at trial in separate cases. The fact that they are both charged is not evidence that either is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor must prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021, within open charge. The prosecution has introduced evidence of a statement that claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement that is given to you. If you find the defendant did make the statement, you may give the statement whatever way you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of fact. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and tried to hide after she was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons such as panic, mistake, or fear. However, a person may also run or hide because of consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. There were evidence that before the trial, a witness or witnesses made a statement that may be inconsistent with his or her testimony in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness or witness's testimony was when testifying in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness and or witnesses said in the earlier statement when determining the facts of the case. The lawyers agree on a statement of fact. These are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side is having more witnesses. Instead, you should think about what each witness, about each witness and each piece of evidence and whether you believe them. Then you should decide the case. Then you must decide the case. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with that. The lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what that witness's testimony would be. You've heard testimony from witness Detective Edward Bobrowski, who is giving you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses or police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by a minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant was charged with the crime of involuntary manslaughter.
These are the key instructions.
The prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Muir. That is, that Tate Muir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Muir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Honda Juliana's death, the defendant acted in a grossly negligent manner. In count 4, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Justin Schilling. That is, Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing an act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. As I explained earlier in my instructions, the prosecutor asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control the minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, the defendant knew of the facts that gave rise to the duty. Third, the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Madison Baldwin was directly caused by the defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so.
Hey, could you grab me like 10 things over there?
The defendant is charged with
My
arms.
Yeah. Yes.
To prove this charge, the prosecutor must prove each of the
I'm
following
live streaming.
beyond a reasonable doubt. First, the defendant had a legal duty to take Weir.
Shut
The
that
legal
door.
duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control the minor child
Hey, Joni.
so as to prevent the minor child from intentionally harming others, or prevent the minor child from conducting themselves in a way that creates unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows for his reasons to know that they have the ability to control the minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Tate Weir was directly caused by defendant's failure to perform this duty. That is, that Tate Weir died as a result of defendant's failure to exercise reasonable care to control a minor child so as to prevent the minor
What's up, Adam?
from intentionally
Morning,
harming
brother.
others, or the minor child from conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter, resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Hannah St. Juliana. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child, and B, the parent knows
Yes, Sally.
an opportunity for exercising such control. Second, the defendant knew the facts that gave rise to the duty. Third, the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by the defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of the defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control the minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the
Thanks, Tina Du.
duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Justin Schilling was directly caused by the defendant's failure to perform this duty. That is, that Justin Schilling died as a result of the defendant's failure to exercise reasonable care to control the minor child, so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others. When the defendant knew that she had the ability to control a minor child and knew of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, we must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, we must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable.
That was the most important instruction she's given.
Means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find the defendant was grossly negligent, we must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring someone. First, the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before. I'm not sure we did the greatest job of this, but I previously is to be precluded from using the shooter's name.
Aloha, the Big Island. Welcome. She's not on mic, that's why.
You should first choose a foreperson. The foreperson should see to it your discussions are carried on in a businesslike way, and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for that, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide to go wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and with conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise from deliberations, you may submit them in writing in a sealed envelope to my clerk. Possible penalties should not influence your decision. If the defendant is found guilty, it's my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your focus written note and give it to the clerk. It's not proper for you to talk directly to me, the lawyers, the court officers, or any other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your vote stands. Therefore, until you return with the unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate with me, take your notes and full instructions. I believe that the defense exhibits are hard copy, and the prosecutor has their exhibits on drive. We have a computer that we can set up in the jury room, and you can look at those exhibits. If you want anything else, you can let us know. But I think it's on drive, right?
The quarterly USB or hard drive.
And Your Honor, I just want to make sure that mine are in the binder. I left it fresh.
Okay. Yeah, we're this and I'll be this. Okay.
Hey, Thin Mint.
I told you this earlier. We can replay a witness. That it's very possible. And I think I told you this at the beginning of the trial. You can't, however, fast forward to the spot where you have a question and all yell out. You have to hear the whole witness, direct, with the only way that's here both sides, but it is possible to replay this. Right? The defendant is charged with 4 counts of voluntary manslaughter. These are separate counts, and the prosecutor is charging the defendant committed criminal. You must consider each count separately and all the evidence in the case.
So you say that there's no indication from legitimate sources that Ethan engaged in unusual behavior.
It's the full charge, there's questions, number 1, voluntary manslaughter, estimates involvement. You can check not guilty or guilty of involuntary manslaughter, estimates involvement. Count 2, involuntary manslaughter, estimate here. Not guilty of involuntary manslaughter, estimate here. Count 3, involuntary manslaughter as homicide, Juliana. You can find the defendant not guilty or guilty of involuntary manslaughter as homicide, Juliana. Count 4, involuntary manslaughter as Justin Chilling. You can find the defendant not guilty or guilty of involuntary manslaughter.
All right, this is wrapping up. These are the verdict forms themselves.
I'm amazed that we maintain 5 alternates. It's, a credit to how great we were at being here.
Hey, Diz, can you throw down the breakup or the breakdown of the jury that you put in the in our Discord? I believe it was 10 women, 7 men, 5 of those being alternates.
I think this has been a very emotional and stressful event for all the parties, the prosecutor, the defense, and the families, and it's been a lot for the courthouse too. You all have really helped me, life happens, so I am going to sequester 5 of you, but I think your names, my purpose was to take you to Judge Anderson's jury room, all over the bunch, so we'll match up the numbers and we'll, get you on to, I really need kind of words to go about it. We just want to be sure that, we can conclude this trial. Then the other, 12 of you will go into my jury room and start deliberating. I should also say the 5 of you that are sequestered still cannot discuss the case, or do research or Google it, or look at newspapers or what Facebook, you're still sequestered as if you're home. All right, sometimes I would, I would send, I'm gonna keep you for a little while. So if you're still sequestered, you're gonna meet or talk to anyone about the case, and can't discuss the case amongst you 5. The 12 of you can start deliberating momentarily. I'm going to consult the lawyers to make sure that there are jury instructions. Bring in the exhibits, and then you can start deliberating. It's important that you all deliberate when you're all there. If one of you steps out for some reason, you should be deliberating. Maybe you can send us notes about when you want to take a break. I still would like you not to go to the cafeteria, please. And be careful.
Lana, I don't know if the jury is sequestered, actually. I'm not sure. If anybody knows, throw it in the chat.
In any event, I'm going to choose 5 of you randomly. Those 5 of you will go to Judge Anderson's jury. Here is C15. C15. Jury seat 17.
Thanks, CH.
Here is seat 10. Seat 4.
Oh, you know that, Sheila. I would be shocked if James' lawyer hasn't been here the entire thing, for the entire trial.
So 17.
Oh, thanks, filling us cupcake. Thanks for you being here. Aw, cookies.
So if you could, might be best on this side or something.
Morning, Grace. All right. Clock. I'm going to start a clock. I don't have one of those. I've been trying to get Mandy and Stevie to get me one of those verdict clocks, but since I'm not going to be streaming through the whole deliberation period, I'm going to keep track here.
I'm then going to send all exhibits and copies of the instructions for you. All right. And if you all decided to leave,
I'm calling it 8:50 is when they went back. Thanks, Matt. Appreciate that, brother.
All right, for the jury.
Oh, all right. I take it back. I'm going to restart. I'm going to give them, I'm going to call it 2 minutes to get back into the jury room, get settled. They'll have to select a 4-person. So I'm going to start the clock at, I'm going to call it 8:53.
gonna send you. You're giving us- Yeah. Thank you. You're not getting this in hard copy. Yeah, okay. Now here it says, please make sure we have phone numbers for you. And your question, we have copies for all questions. We should have those.
There are 5 exhibits that we didn't include in the USB to the jurors. That's the shooting video. Photograph with the blood in the bathroom.
Okay.
Crime scene photo depicting the 2 victims. The video that was played with Christine Marshall, and the video that's played with Malcolm.
Okay, do you want to be, to sound helpful in that?
This should be made aware of it.
Oh, okay, I'm gonna talk about it before we go. Can you write this? Do you want me to just tell them?
That's fine. I can write a note on the envelope.
Okay. Oh, you can do it. If you can initiate. But
Shannon's checking TikTok.
You can send calls. Read it all the time.
Those are, yeah. Yeah, the binder just has like pages, page numbers. Thank you. That's all.
I hope everybody here will be careful not to have any interaction with any of the jurors.
Yeah.
Oh God, have another Murdoch situation. Yeah, don't talk to the jurors. Let's make it simple.
I think some members of the media have asked the jury instructions, we email to them, and I agree that I would do that. Since I forgot.
What's your signature?
Do you have any thoughts about whether they have raised about the batch previously?
Thank you, Judge.
Sure. All right, so we'll send you those, we'll let you know. Okay.
Thanks, Judge.
All right.
All right,
So,
game on.
this one's- oh, this one.
Got to get her shackled back up. She will wait in holding cell. They might bring her back down to the jail. Shannon will probably, now the state's attorney's office is in the courthouse. So they'll go back to their office, hang out there. Shannon will probably go eat breakfast. And try to find a restaurant and or bar to hang out. It's got to be within 10 to 15 minutes of the courthouse. So when the clerk calls, everyone can race back to the courthouse. All right, so we are on verdict watch. I started it at 8:54. What's that? What's our poll look like? I haven't. Let me pull that up. I don't know where we're at with that thing because I'm watching through StreamYard. So a couple things. This is a really good question by Lana. So the state gets to elect who they're going to try first. If you've got multiple defendants or you've got one defendant with multiple cases under different case numbers, it's the state's decision alone on who they'll try first or what case they will try first. The defense has no say so in it. The judge has no say so in it. It's completely up to the state. Now, I always felt that the state would always move forward with their strongest case first, which should tell us that they felt that the case against Jennifer was stronger than the case against James. And I think that that primarily relates to the fact that when they were going through text messages and just in terms of who had more contact on a daily basis with Ethan, it was his mother. And I think that those are the things that probably swung them towards electing to try this case first. The interesting question is if this comes back either not guilty or as a mistrial because the jury is hung, what do they do with James's case? If I'm correct in my evaluation that I think that they think that this is the stronger of the two cases, do they move forward with that case? You know, because I think that case is basically it's going to lack a lot of the texting. Now, I mean, they'll still have the same argument as to what I feel is the strongest piece of evidence in the case, which is the math test / writing drawings that was emailed to Jennifer. I'm not sure if it was emailed to James as well. And the other thing that I'm not clear on, and if y'all know in the chat, is whether or not when they sat in the office, were they handed the math test that had been altered by Ethan. And the reason that I'm asking that is because if James didn't see the original, like if he was not emailed the original that didn't have the scratched out writing and some of the picture scratched out, that changes the evaluation a little bit for me in terms of what he should have done. But, you know, so I'd be interesting to know that. All right. So let me see. I want to pull up the, if y'all have any other questions, let's get to them. Will the verdict be, I mean, are you asking whether or not, they can't argue it. It can't be entered in as evidence, in terms of, I'm sure that there will be motions in limine relating to the fact that, you know, if Jennifer's convicted, that they can't bring it up. That'll be something that'll be litigated prior to that trial starting. You know, I mean, the question is, you know, as far as I know, and I don't actually know. Does anybody know out there? Was there a change of venue, or are they in the county where it took place? If anybody knows that in the chat, I'd appreciate that answer. You know, when you have a case like this, the odds of the jurors, like that would be something I would be asking in Vordaer. Yeah, thanks, Meg. Is it that bad? I mean, I have a pretty deep voice. It's definitely a little scratchy. There's no question about it. I've been fighting this cough. When I had Jay on the stream, the marathon stream Friday, like there was a period like 4 hours in where I literally thought I was just losing my voice, like that it was gone. I tried not to talk a lot this weekend, but I went to a birthday party at my friends, and there's a lot of people there and live music with a bunch of amazing artists that were just jamming in my buddy's jam lab. His he calls it his beat lab. But it was pretty awesome. I was actually going to try to live stream it for you guys because it was pretty amazing. So yeah, does anyone know, are we in yeah, Adam, truth, dude. I do need that. Like I've got singer friends. I was trying to hit Shira up and ask her what her routine is because she takes very good care of her voice. I bought tea yesterday. I didn't make some this morning. I should have. I woke up a little late, and I was 50-50 on whether I was going to stream because of the voice thing. Yeah, I don't think I have the vid, Diz. I don't think I have the vid. I think I have the other thing, whatever the other thing is, the persistent thing that sticks around for like 3 weeks. And I'm so late. I have I have 2 scripts done for Garcia that I haven't read because my voice sounds like shit. And the podcast is in perpetuity. So I've been just hoping that my voice will get better. So I hope I kind of answered that. But I was saying, like in Vordaer, I would ask the jurors if they were aware of the verdict in this case. Yeah, I hope I don't get strep. I haven't tested for it. I don't think so. Yeah, I get everything from the kids. Thank you, Dizzy. No change of venue. So it's in the county where it occurred. And you have to imagine that they Manuka honey. All right. Can I get that at my local market? Or do I have to? It sounds Hawaiian to me. Or Samoan, one of the two. I don't know. Yeah, I know. I hear you, Big Island. Yeah, and Darren, my producer's been in town for about 11 days. Like the big plan was to get a bunch of Garcias in the can so that we were ahead of the game. But can't do anything with the health. All right, let's see what we got. Jen, this was insanely generous of you. Thank you so much. Thank you. I really, really appreciate it. Joey Jacks. Joe broke 7K. He had a big appearance on DeSella's, the Grizzlies channel over there over the weekend. Got a ton of subs over there, well deserved. They're smart like we are. They know Joe's a treasure. We all love Joe. Joe's the best. He's my boy. I'm overdue for having him on. I jumped on his a couple weeks ago. I want to have him back on with me. I'm probably going to schedule that imminently. Lori, thank you so much for becoming a member. And I appreciate it. I see you in the chat. I appreciate your kind words. I really, really do. Grin for me. Welcome to the family. Aw, family hugs. For you too, Lori. Aw, fam hug. Thank you guys for joining. Becoming members of the family. Jen, even more generosity. 10 more bucks. Woo, $10 holla. The $50 holla, though, like blew my hair back. It's a good way to wake up. I was like, wow. Incredibly generous. Spitfire, thank you so much for that generosity and welcome. Saw you in the chat too. Appreciate you. Thank you for being here with us. And I hope that you'll join us all the time. We have a great community here. Amazing people in the chat. I love our chat. Our chat's so good. It's so good. And I love that we have both sides on this thing. I really do. It's so like, because this is that case. It's what I was saying prior to this case. If y'all aren't like, you can't look at it in a vacuum, because it's not a case that can be looked at in a vacuum. It is going to have one way or the other. She's found guilty. It changes the game for every parent in this country. It just does, because at that point, there's a shift. There's been a seismic shift in the way that parents are going to be treated by the criminal justice system in terms of liability. I was having a great Twitter debate. I wouldn't necessarily call it a debate, with Adam Malone, who's a brilliant guy who I love. And y'all, can you go like, and I always want people should be subbing to his YouTube channel, which is a parody channel, which is phenomenal, just hilarious. It's Real Crime with Cletus. But everything's like misspelled. It's really funny, and it's really smart, and it's good. I actually I'm gonna have to message. I've got an idea for the morning drop, which would include Adam. So I'm gonna message him. If you're still here, Adam, I'm gonna DM you over the next couple of days, brother. Danny B, Defense Digest podcast. There was a recording Ethan Crumbly made the night he was locked out. It's being called a manifesto, and a lawsuit has been filed against the school with info that didn't come out in trial. Interesting. Now, I thought I had asked about the civil suits against the school, and I thought Dizzy had said that they were dismissed. Now, civil cases, you can get them dismissed either through a motion to dismiss or through what they call a motion for summary judgment. They're different. There's different burdens that have to be met for both of those. Summary judgment is basically saying that there's no issue of fact that a trier of fact can decide, that it's all straight law, and that the law is settled, and that the law isn't allowing for that claim to come forward. So that's a summary judgment motion. That's kind of what that is. Motion to dismiss. There's many ways you can go about a motion to dismiss. Typically, they start by attacking the complaint, stating that there's no real cause of action that was filed. But there's many ways to go about it with the motion to dismiss route. But if somebody can let me know whether or not that's true, because I'm curious. Because I thought Dizzy said that they had filed civil suits and they were dismissed. They didn't make it. Yeah, I like Danny B. I could tell you, I know that when Ethan's his journal became public, which I believe, and I've been contemplating, and somebody had asked in chat in terms of when they decided whether or not he was going to be charged as an adult and or a minor. And again, that's the state's decision. The bigger issue was whether or not, because the Supreme Court of the United States, in this Miller case, it basically come down with a test as to whether or not a child or a minor under the age of 18 can be sentenced to life without the possibility of parole. Okay, so they were dismissed in the appellate court. Oh, okay. So if they were dismissed in the appellate court, that means that the plaintiffs got a verdict and that the defense challenged it. Huh. I'm sure, Diz, I'm going to ask you to do what you always do. Can you find that opinion for me? I'd love to read that. But going back to the Miller hearing, so they had a Miller hearing, which was a 4-day hearing regarding sentencing with respect to Ethan. It was really interesting, and a ton of stuff that we didn't see here. And a lot of that had to do with the fact that Ethan had taken the fifth, meaning that if he would have been called to the stand, he would have taken the fifth because he's got an appeal pending. So his lawyers on his behalf had essentially had him pleaded the fifth right there, which meant that Jennifer Crumbly and or her attorney Shannon Smith could not confront him, which is why a lot of the things that would have probably otherwise come in were not admissible because they're hearsay. Like, the generic definition of hearsay, which when you go to law school, you quickly learn that probably the most difficult rule of evidence to really understand and have a true kind of I'm gonna sneeze, hold on. Excuse me. And have a true understanding of it is definitely the hearsay rule. And I mean the general definition of hearsay is it's an out of court statement being offered to prove the truth of the matter it asserts. So whatever the statement is, there's a lot of exceptions to the rule, but even the exceptions are tricky. Because out of court statements are, if even if you have a witness in the courtroom that made a statement outside of the court, it's still considered hearsay. A lot of times you can find a way to get it in, but it's an incredibly complex area of the law. I think people have a kind of a generic understanding of it, and people like to use it. But in terms of the legal analysis of it, it's pretty intense. So I was thinking about whether or not to stream some of that Miller hearing. I mean, like that's where you hear just like if you guys are just kind of jumping into this case with this trial, and you were limited to knowing what was going on in terms of Ethan in his mind leading up to this, and this was all you saw, it scratches the surface. I mean, he was damaged, massively damaged. His writings in his journal. I mean, this thing was planned. I mean, like the shooting was planned. He knew when he was going to do it. He was working towards getting his parents to get him the gun. And, I mean, the day before, his last journal entry was chilling to the bone. I mean, he was flat out just said it was going down that day. And none of that came in at this trial. And I had like kind of in my Twitter questions, I had somebody had X'd or tweeted at me that they thought that the parents, Jennifer and James, had seen the journal. It's my understanding that they did not prior to. If they had seen that journal prior to, this would have been a 5-minute verdict, because it was he couldn't have been more clear in that journal. I mean, like that journal, you see that thing, it's like the math test on crack. It's unbelievable. I mean, it's so evident where he was at mentally and what his intentions were. Meg P, $10 holla. Thank you so much. You're always so generous. You're an always giver. That's what I call the always people that always are being so generous. Always givers. I'm expecting Mandy to make an emoji for the always givers of the crew. Dawn, another always giver, $20 holla super sticker. Thank you so much. Look at that. Joanne, 4 months. Joanne, you might be like one of the super OGs, I think. And yes, this is the verdict. Well, we're getting to the verdict. They're back there deliberating. Thank you for being a fam for 4 months. Love you, Joanne. You're awesome. Catherine, another always giver. Thank you so much for that $10 holla. Let's see. I'm going to go through. Yeah, no, I agree. It's like, yeah, that's what I was saying. It's like they're shocking. It's so shocking. Like, it's just, you see, like, I don't know. I don't know if I agree that they show how neglectful the parents were like I don't know. It's such a hard question. It's easy to sit here on the sidelines and judge somebody else's parenting, but it's like I know, like, and I consider myself to be an excellent, loving, hands-on parent. But do I spend too much time on my phone? Yeah, I do. It's like I just do. Where I should be engaging with the kids, I do. I think many of us are guilty of that. And is that to the extent where I could miss things? Maybe. I don't know. That's why I've been a little hesitant to judging the things leading up to the date. And to me, the strongest piece of evidence without question in terms of what would probably more likely than not have me voting guilty in that deliberation room is that math test. As soon as you see the words help me, I honestly, like, for me, I can't get over that. I just can't get over it. The thoughts won't stop. Help me, blood everywhere. Like, I would not care what anyone was telling me, whether one way or the other in the school. I wouldn't care if the council were saying, oh, we don't think it's a big deal. I do. I think it's a huge deal. Like, I become immediately like petrified of what's going on with my kid. And I'm like, oh my God, like, how long has this been going on? In kind of like a real low key bit that came in at trial was the fact that neither of the parents embraced their kid, or like, I just don't see a world in which if I saw that and was handed that document, like right then and there, I would immediately go to my kid and I'd say, I'd ask them to clear the room. I'd say, my God, I need to talk to my child like right now. And I would be like absolutely trying to get into their mind and be like, what's going on? Are you okay? It's like I just don't understand how that doesn't happen in this situation for me. And and it's that thing with this case. It's like you've got eh, it's such a tough case because I'm promising you right here, if she's found guilty, it's going to be a watershed case that changes everything moving forward in this country in terms of how we are going to be treated as parents by the criminal justice system. I'm like, that's not speculation. I'm just cast it, put it on a tablet. It's like, that's it. It's gonna change everything. Sorry, guys. So I like, for me, but like what's gonna be going on in that jury room is the other part of the conversation, which technically it shouldn't be. The jurors are charged with only dealing with the law and the facts. That's it. They're not supposed to be considering, oh, they can't worry about the consequences of this verdict in terms of reaching a verdict. We're not allowed to do that as jurors. Can only deal with the law and the evidence that was presented at trial. But like I'm always saying, I say it all the time. It's like we're humans. We're not robots. When something is in your mind, even if it's subconscious, it is affecting your thought pattern. Like we can't pretend it doesn't exist. It's like, in trials, if something happens in the middle of a trial where something is said on the stand and, one of the attorneys stands up and objects vehemently and, asks for the judge to strike it and to instruct the jury, give a curative instruction to the jury saying, look, you cannot take that into consideration, and it's like, and they do, but does anybody really think that something that's said that has an impact potentially on the verdict is going to be forgotten? Like, even if they're not going to apply it in coming to the verdict, it's in there and it affects the way that you think. It's like it's such a it's just a fallacy. It's like a legal fallacy that, a curative instruction helps, get rid of that issue when the jury's going back to deliberate. I've always felt like it was complete bullshit. And I think that most attorneys would agree. It's one of those things you can't unring a bell, once it's wrong, it's wrong. I used to do that move all the time in court where I'd ask a question on cross-examination that I 100% knew was going to be objected to and it would be sustained. However, I wanted the jury to hear the question itself just to get the concept in their mind. It's a bit of a slippery move. There's no doubt about it, and you have to toe the line very carefully because you can't get too slippery with it. Otherwise you're, potentially looking at a mistrial, which is a nightmare. But it's one of those things where, and it's the same concept of this, where you've got this societal issue that is in the sidecar of this case. It's like, it's part of this case. All right, hold on. I had to hit the cough button. So it's an important case. It really is. All right, so I want to take a peek at where we're at with that poll. I want to see what you guys are thinking about how long you think these will go. I'm going to jump into my studio here real quick. Bear with me. Okay. Okay. Okay, so we're at 55% over 5 hours and 45% under 5. Okay. Let's do one more. I'm going to end that poll. So I wouldn't call it a super majority, but a majority think that this will go 5 hours. Now, remember, I did not hear, it sounds like in Michigan that they may do it the way that they do it in the courts that I practice in, wherein the jurors are going to select a foreperson as opposed to the judge. As we know in Murdoch, Judge Newman selected the foreperson. And the foreperson is very important. I kind of like the random selection of a foreperson because I'm always concerned, with who will end up being a foreperson, because that foreperson is given kind of I wouldn't call it like that they're put on a pedestal by the other jurors, but I think that they may be given more weight, and it's typically an alpha type personality that is the foreperson. Because if it's the jurors selecting it, at that point, that the person put their name out there to be the foreperson. So that they're an assertive person, that they actually want to be the foreperson for whatever reason, because it's fair game in a jury room for them to go at it and for them to try to change each other's minds. I mean, that's what the process is about. Like, there's nothing wrong with that. And it's one of the questions that we ask always in voir dire is, look, if you are 1 out of 12 that is of the mindset that the person is either innocent or guilty, and you've got 11 other jurors in your face, are you going to be able to stand your ground? and like with us, like I always tell the jurors during, when we're questioning them, I'm like, we just want you to be honest here. There is no wrong answer. The worst thing you could do is give answers that just aren't truthful as to who you are fundamentally. And if you're a timid person, which there are many people that do not like conflict, that don't want to engage in conflict, that will do things to avoid conflict, I don't necessarily want that person on a jury, because I don't want somebody who's going to be able to be convinced easily to change their vote, you know? Excuse me. So, um, yeah, I don't it's so tough back there. I've been dying to be a juror. I've been dying to be a juror. Like I've been called a couple times. Of course, as soon as they find out I'm an attorney, I'm bounced. But um, being a juror is it's the most important civic duty that we have. I know people like that. "Well, I'm trying to get out of jury duty." I don't know why. I've never spoken to anybody that has served on a juror that regretted it. And it doesn't matter what type of case it is. It's such a integral part of our society. I mean, there's nothing like it. It really isn't. And it's like, it doesn't matter what type of case it is, really. It's like, as soon as you kind of get sucked into the, just the minutia of the case and the facts, it all becomes interesting. It's all, and I mean, you're the one sitting in judgment. I mean, who doesn't like, in a case like this, they've got a huge duty on their shoulders. Like these 12 folks are could potentially change the fabric of society today or tomorrow, whenever they come back. I anticipate it's going to go well over 5 hours. I really do. I think they'll be going at it. I mean, like everything that we're doing in the chat, everything that y'all are doing in the chat is exactly what's going to be going on back there. It's not going to be any different, and there's going to be people stuck on their position who just will not change their mind. All right. So I'm going to do one more poll. Now, this poll, it's what Allison's always asking me to do. It's not your opinion on what you would vote. Okay. It's your prediction on what the jury would vote. So now the jury, so I'm not going to have hung as an option. It's guilty or not guilty. That's it. And it's again, it's not what you would vote, because I've done that poll a couple times. It's what you think the jury is going to come back with. All right. And they're two very different questions. Okay. I'm excited to see this. Can I get kicked from being nah, I don't think so. I don't think so. Like I mean, it's just like, I mean, they're anybody who asks, "Are you a trial observer? You watch trials on YouTube, or do you watch streams of trials?" It's like I want well-informed jurors, I really do. I want jurors that are familiar with the system and familiar with trials and because they're helpful. I mean, you want people having an understanding of what's going on, because I mean, you'll get jurors in there that have never been a part of the judicial system at all. And it's like, it's a very foreign world. So yeah, no, I mean, it would boil down to if they question it. So in most counties, what happens when you get, you get your notice of jury duty, you have to call in typically, say, "Oh, okay, I got the notice, I'm available." And then they'll send you, like in our counties, they send kind of a questionnaire that's got just basic info, date of birth, where you live, are you married, For how long? Do you have kids? You know, and then it'll ask some more specific things. You know, do you have any relatives that are attorneys, judges, cops? You know, and it'll have various questions like that. Where are you employed? Are you a college graduate? Or what's, you know, what's your, what is the last year of school that you attended? You know, so you're trying to get some background. Because picking the juries is everything, y'all. It just is. It's like it doesn't matter at the end of the day, you know, what you're arguing, because it all boils down to a jury. And there's one thing that is an infallible in the law. It's that you never know what a jury's going to do. There have been cases where Alice and I were like, you know, walking out of the courtroom after the, you know, after closings and after the jury's gone, and I'm like, wow, like we crushed that, and then come back guilty. And we're sitting there, mouths dropped, and like, just, you never know. You can't know. And especially in a case like this, you know, because it's like lawyers love that conversation about, you know, what does a quick verdict mean? Is that bad for the state? Is it bad for the defense? And you just can't know. It's like, because like sometimes I'll be like, oh, a quick jury, it's, you know, it's good for the defense, you know. But if like in a case where there's like a lot of issues of fact, it's really hard to know. I could just tell you that what it's like when you finish a trial as an attorney, whether you're the prosecution or the state, or I'm sorry, the defense. First, you're hit with like the overwhelming feeling of relief that you're done with it, that you made it through it. You know, that's why I get a little defensive when I see people picking on Shannon Smith, or frankly any lawyer, even prosecutors. Sorry, all that, you know, are like, oh, sloppy. Oh, you know, she's so unorganized. Oh, it's like, unless you've tried a case, and I hate to be that guy, you really just have no understanding of how hard it is to try a case. It's not, you know, when you get a case that runs smoothly, and there's no such thing as a perfect trial. I mean, as hard as we may try to have it perfect, it's never going to be perfect. We're humans. We all make mistakes. But I, you know, I took exception to a lot of people like saying that they didn't like Shannon, that she's whiny. And I'm super protective of women attorneys, because they had to go through a lot of shit and a lot of misogynistic bullshit for a long, long time. And they still do, from their male counterparts, in terms of them being dismissed, and in terms of them being undervalued. And I'm not here for that, you know. And when I see things like people calling her whiny, kids are whiny, adults aren't whiny, you know. And she was doing her job. She was objecting to things that she needed to object to. And, you know, for whatever reason, she was trying that case for the better part of what I watched alone. And if you saw those stacks of evidence, in terms of that leaning tower of Pisa of files that she had, I want you to, for 1 second, try to think about trying to keep up with the state in terms of not knowing who they're calling next, which in this case was the case, and which oftentimes is the case. Like, the state can either play nice, or they don't need to play nice, in terms of giving us their witness list and letting us know who's going to be testifying in what order, because you're trying to prepare or who they're going to call and who they're not going to call. Because we can get a witness list that has 50 people on it, and the state doesn't need to tell us who they're going to call and who they're not going to call. and in what order. And so when you're trying to prepare for the next day and you have no idea who they're going to call, it seems shitty because it is shitty. It's like I wish that was not the way that it was. But I mean, it's the same thing. We could do the same thing with the state, but I'm not trying to play gotcha. Like I'm just trying to get to the truth and trying to get some actual justice in any case. Like I never play that game with the state. I'll let them know who we're calling. It's like I don't need to try to win by surprise. It's like, just let me know who you got coming. So in this case, they didn't let her know who they were putting on, and she had no help going through. She's trying to listen to every single word that's being said because, again, objections exist in courts of law to preserve the appellate issue. If you fail to object at trial, or if you failed to file proper motions pre-trial, and those end up being the reason, or potentially being a reason why your client's convicted, you have waived that issue for appeal, meaning you can't bring it up because you whiffed and you missed it. So like, she's trying to listen to every single word they're saying and objecting if she finds it to be objectionable, And so it's like, people sweating lawyers for doing that. It's their job, people. Like, if you don't like objections and sidebars, you probably shouldn't watch trials, because you're never going to find one that doesn't have a shit ton of them. So I'm going to try to get Shannon on here. I emailed her. Like, I just, it's such an important case. In my view, I disagree with people that feel like she didn't do a good job. I thought she did a great job, especially in light of the fact that she had no one there as a trial partner to help her. Like Allison and I, it was always Allison and I. Like, Allie never went to trial alone. I never went to trial alone. You need that person that's helping you. If Allie was first chair, I'd be going through. If she told me she needed things, like, I need this exhibit getting ready. Can you get this exhibit ready? Can I get that exhibit ready? I'm trying to help her move through so that when people like y'all are watching, you're not sitting there saying, oh, they're so unorganized. They're so unorganized. Oh, look, they're having to go through. I mean, we're not robots. And trials are like, your brain is so hyper focused on what's going on in that courtroom. Like, you're just not cognizant of the people in the gallery. You're not cognizant if the case is being televised. It's like you're not thinking about that stuff. Of course, you're aware of it after the fact when you're out of the courtroom. I mean, clearly Shannon Smith was scrolling. I don't know if, like, some people were saying recovery addict with his I'm sorry counter was what they were talking about. I don't know if that made it to TikTok, but that's where she said it. I don't know. I'm very defensive when it comes to people attacking women lawyers. I don't like it. I'm not going to have it. Not on my watch. It's just, it's a shitty way to be. And frankly, women are phenomenal lawyers. It's like I was saying the other day, I think if most police officers were women, we'd live in a much different world. I don't think there would be nearly as many cop shootings if women were cops. I don't know. Maybe that's just me. All right, so let me take this thing off. Let's jump on here. So, all right, y'all. I'm gonna give this voice a rest. Yeah, I'm definitely gonna try to get Shannon on here. Oh, Charlotte threw a question up. Do you think a guilty verdict will allow prosecutors to file charges against parents of shooters who have already been convicted? Probably not. Statute of limitations will probably, unless it's a charge like this, it's got to be a charge that, there, at least in Illinois, there is no statute on murder. There's no statute. You can charge it whenever, on many of the major felonies, there is no statute. So theoretically, depending on what the charges are, because much like in civil cases, there are statute of limitations in terms of when the state has to bring the charges. And if they wait too long, they've blown the statute, they can't come at them. So yeah, I mean, I think that it definitely could be a thing. All right. Danny, Defense Diaries, can you please pull up the lawsuit that was filed against the school? It has info we haven't heard before because it didn't come out in trial. Yeah, I'm gonna have Dizzy send it to me. She may have already done it. I won't do it on this stream just because of my tender voice. So what the plan is, I am going to keep a watch. Okay. I gotta drive Darren to the airport today at 11 o'clock. So if for some reason it comes back early, I don't know that I'll be able to stream it. And we could get action in terms of, because there's 2 times that the lawyers will be called back to the courtroom, and it's either if there's a question by the jury, they'll call everybody back, or the verdict. So, if it's a question, which frankly, I would love to stream the questions too, because the questions are so telling. They're so telling. Like you can really glean where a jury's head may be at by what question they're asking. Like Alice and I like way overanalyze when they ask a question. We'll sit there trying to figure out, oh my God, does that mean? Oh, Christy D. She's another always giver. Thank you so much for the generosity. And it's true. Like, I mean, I'm adamant. I'm adamant about it. It's like, and like people just don't know. Like, I go into court with Allison and, a judge calling her sweetie, or, I have some dickhead guy like the state's attorney in this case just being condescending. I mean, I'll just tell you, in that Garcia case, like Don Klein and his treatment of Allison was a problem for me. It was a problem. It was like, that was the one time in our career practicing together where I slipped out of professionalism a little bit and into this guy's attacking my wife mode, and shit got intense, which is a challenge when you're a couple trying cases together. It's like, I take umbrage where, if she was just a fellow employee of mine, I might take umbrage, but when she's my wife, I seriously take umbrage, and it's just, and Allison's a rare beast in the sense that she doesn't give a shit when men are demeaning her. And I'm talking about men attorneys, male attorneys, or underestimating her. She could give a shit less. She doesn't care. But like there's a lot of women that do and are sensitive to that kind of thing. And it shouldn't be happening. They shouldn't have to deal with that. Women are phenomenal attorneys. Like the lawyering is genderless, period. It should be. Like it should never be, like I'm seeing people like, oh, it's like, I was going to give Jay a little shit. He was putting up like Shannon in her hair. I'm like, come on, dude. It's like, I'm like, you're not helping the women attorneys of the world. But yeah, I mean, it's getting incrementally better. But we have a long way to go as a society, in my estimation. And that's why I try to be a loud voice, an advocate, for people to cut the shit. It's like that, like somebody had like, there was a Twitter thing where somebody literally said that, Shannon was whiny. And I'm like, it's such a cringy word for me when you're talking about a woman attorney. What? Because of the way that her voice sounds. It's like the same thing that I hear, like, in the podcast game where we're talking about women with their vocal burn. I'm like, dude, like, give it a rest. Like, seriously. Yeah, I know. It's surprising, man. It's surprising, Matt. It's absolutely true. It is mostly women. And it's, and I hate to say this, y'all, but y'all, and I'm talking about women, are many times your own worst enemies. Like, just, I'm trying to get it so that y'all are running shit. Do you understand that? Like, men have had their run, and we see how it turned out. And I think it's old white dudes and just dudes in general running shit. I think we had a good run, or we had a run. I don't know if I'd call it a good run. If you look back at the history of men running shit, I think there's a very strong argument that it wasn't a good run. And I think I'm ready. I'm ready for women to take their turn at the wheel and see how shit turns out. I have a strong inclination to feeling that we'll be living in a better world, but maybe that's just me. I don't know. So all right. And the one other thing I want to talk about before I jet, like, so, and I started to talk about it, like that first feeling that you get as an attorney when you finish a case like this is just overwhelming relief that you made it through it, because it's so stressful, so stressful. And then that is supplanted by the terror of the jury being deliberating, because it's like, as an attorney, like, if you're the state, you got to believe that they want this guilty verdict, not for their ledger. And yes, I mean, that's a part of it for the state, I mean, that, like, and I think that there's probably certain states attorneys that just kind of look at it as like another notch on the belt. Yo, yeah, my conviction rate's 99%. But like, in a case like this, where they think that, that it's like a socio-political type issue that's at stake here. I mean, they're feeling the stress, and they're feeling the stress because they want to be able to give what they feel is some more justice to the victims' families. I mean, they feel that. And for defense attorneys, in a case like this, where clearly she's not the actor, but there is this question, is she culpable? And the only way I can try to explain what it feels like to be in that period of time while you're waiting for the jury to come back with a verdict is maybe sitting, like, this is as close as I can get to it, like, kind of the stress level that you're feeling and all the things that are kind of running through your head is like, if you're sitting, like, if somebody that you love and care for has gone in for surgery and they've told you going in, that they don't know whether, it's like that they don't know whether or not they'll make it. It's a very difficult surgery, that they can't, like, obviously they can't predict the future. They can't make any promises as to whether or not they'll make it out. And that period of time, that 7, 8, 9, 10, 11 hours while your loved one's in surgery, while you're sitting in that waiting room, it's very similar to that. It's a very similar feeling to that. And then, coming in when you get the call that the verdict's in, and it's like, Alice and I will typically be at a restaurant and they'll call, and like, we won't even talk in the car. It's like, it's just like, you just kind of sit there and you drive over there, and then you're standing there next to your client. I'll never forget, I had a case. Guy was like a father of 3. His wife had just had a baby. It was a drug case, and they had our guy pegged as the lookout, and it was a reverse buy, which is when the undercover cops, are supplying the blow and getting the person to buy the drugs. That's what they call a reverse buy. And hard fought trial, and they came back. Jury comes in, our client's standing right next to me, and my heart's going like this. You have to imagine, if you're the defendant in a case like that, and you're waiting for those words to come out of the jury's mouth, it's pretty intense. I don't know that there's a more intense moment in anybody's life than that moment, especially when you're looking at, for that guy, it would have been 15 years. He would have missed all of his kids growing up. It would have, I mean, it's a life altering thing that's happening in a massive way. and as soon as they read the verdict in that case and they came back not guilty, like his nose explode. He started bleeding, like got a massive nosebleed because his heart was going like this. He was pumping. It was like it was crazy. It was such a crazy thing. And it's like not an uncommon thing to happen because of the stress of that moment. So I can imagine both sides are, extremely stressed out right now. And I'm anxious to see where they're going to come back. All right, let me see what we got. Wow. Wow. Look at the poll. The poll, man. Shoo, boy. That surprises me, y'all. That surprises me. Like that's a massive shift. Like not guilty is winning right now. How many people have voted? Why can't I pull it down? Wow, that's something. That's all right. 185 votes, and it's 51 not guilty, 49 guilty. Woo! Damn. Wow. That surprises me. That's wild. I mean, that's the thing. That's the thing. I mean, like it surprises me. Now I'm curious. Are those of you voting not guilty? Are you really of the hung in your put because you're not allowed to do that. You can't do it. You're not allowed. Like you have to make a choice. I'm not allowing for a hung jury. That's my rule. There is no hung. So if you voted not guilty because you think it's going to be hung, you can't do it. You have to make the choice. You have to go guilty or not guilty. You're not jurors. I'm going to force you to go back there and deliberate. I'm not going to let you off the hook. So I'm curious. Ooh, 52 to 48. Man. Wow. That's surprising to me. I mean, I'm a defense attorney, and y'all know I'm pretty big on the Constitution, and I'm definitely not the defense attorney who thinks everybody's or the state never meets their burden. The state does a good job, and somebody's guilty. I'll be the first one to say, yeah, that's guilty all day. This case is different, though. This case is definitely different. But for me, I'm voting guilty, and like knowing, like hyper aware of what it means for society moving forward. I've been the one that's screaming the most about it on all the YouTubes I've seen, just of what it's going to mean to society. It's one of those cases. So well, all right. That's interesting. Super interesting. I'm proud of you guys. 206. It's growing up. 52. Wow. Wow. That is impressive and shocking to me. I'm not gonna lie. It's very, very shocking. Man. All right. So what I'll do, y'all, is I will keep an eye on it, and I'm sure that my mods will be hitting me up. Because I would like to stream the verdict, definitely. And if I am available, I will definitely do that. Because I'd like to share that with y'all, and I'd obviously like to have a conversation because I think it would be interesting. Either way it goes. I mean, to be obvious, or to be like completely frank with you, I think more likely, my guess is this thing's going to go until tomorrow. I think that they're going to deliberate all day. I was so relieved that the judge did not allow them to start deliberations on Friday. It's always my biggest fear as a lawyer for a late Friday deliberation start, especially if it's been a long trial, because there's going to be jurors that are like, dude, I'm over this shit. Like, I'm not trying to come back here on Monday we need to come up with, let's do a verdict. Let's go. Let's go. Because, you know, they always do the straw poll first. And if there's like one person, one holdout, you know, like, and you got like that Friday thing just hanging there. It's a thing. It's a thing. So and both lawyers had said that they were good with them starting deliberating on Friday. And the judge is like, I don't know. I don't think so. So I was relieved that she did what she did. I thought that was a really good call. Oh, thanks, Diz. Remember when I was talking about Dizzy and like how if she lived in Illinois, I would have like sucked her up as a paralegal at the very least. I've been trying to talk her to go into law school. But man, those law school tuitions, whew, they a lot. All right, y'all. I love you guys so much for hanging with me. We were 300 strong at one point. If you haven't subscribed, please do. We broke 12K on Friday, so thank you all so much. Subscribing is free. Subscribing is free, and if you really like the content, become a member. Get a fam hug. I love to give fam hugs. You know, because we're going to give you a lot of great content. We're excited about the morning drop coming. It's about what hired me and fired me the same. I don't know. You're a pit bull. I like pit bulls. I enjoy the pit bulls. I especially enjoy women pit bulls. They're a big fan of theirs. So yeah, but like, share, subscribe, join as a member. We love having y'all. And I keep talking about, keep threatening about doing like a members only thing. And our membership is growing massively. I think I just saw we're over 500 members, which is super exciting. And I'm super grateful. And I want to show my love and support for y'all supporting us. So I'm going to figure out something cool to do for members only. Probably not this week, but next week. And I'll let you know. I'll let you know what it is. Like, I'm on Kick. I haven't like set it up proper. The thing that's cool about Kick is you can stream things like movies, shows, Dateline episodes. I saw somebody had mentioned that. You know, without getting like a copyright ding, like YouTube, they'll shut down the stream like immediately. So, but I'll think of something cool. And I'll do it because I love hanging with y'all because you guys are the best in the business. So thank y'all for joining me. I apologize for my voice. I knew I was gonna have to struggle bust through it. But I did because I love y'all. And thank you for showing up for me. I really appreciate it because without you, you know this, I'd just be an old man talking about old and new cases. Talk to you next time.